What is succession? It is the mode of acquisition by virtue of which the property, rights, and obligations to the extent of the value of the inheritance of the person are transmitted through his death to another, or others either by his will or by operation of law. Elements of succession. 1. Decedent. 2. Successors. There are two kinds of successors: heirs, those who are called to the whole or to an aliquot portion of the inheritance either by will or by operation of law. Devices or legatees, persons to whom gifts of real personal property are respectively given by virtue of a will. 3. Death of the person. However, a person may be presumed dead for the purposes of opening his succession. See rules on presumptive death. In this case, succession is only for provisional character because there is always the chance that the absentee may be alive. Fourth, inheritance is the subject matter of succession. It includes property and transmissible rights and obligations existing at the time of his death and those which have accrued thereto. Since the opening of succession, succession refers to the legal mode of which inheritance is transmitted to the persons entitled to it. Inheritance, on the other hand, refers to the universality or entirety of the property, rights, and obligations of a person who died. Kinds of succession. Testamentary, that which results from the designation of an heir made in a will executed in the form prescribed by law. Legal or intestate, that which takes place by operation of law in the absence of a valid will. Mixed, that which is effected partly by will and partly by operation of law. Kinds of heirs. Compulsory, those who succeed by forced law to some portion of the inheritance in an amount predetermined by law, of which they cannot be deprived by the testator except by a valid disinheritance. Voluntary or testamentary, those who are instituted by the testator in his will to succeed to the portion of the inheritance of which the testator can freely dispose. Next, legal or intestate, those who succeed to the estate of the decedent who dies without a valid will, or to the portion of such estate not disposed of by will. Kinds of will. Notarial, an ordinary or attested will. 2. Holographic, a handwritten will. Notarial will. A valid notarial will must be in writing and in a language or dialect known to the testator, subscribed at the end of the testator himself, or by the testator's name written by some other person in his presence, and by his express direction, attested and subscribed by 3 or more credible witnesses in the presence of the testator and of one another. The mandatory part is the signing on every page in the witness's presence. Note also that test of presence is not whether they actually saw each other sign, but whether they might have seen each other sign had they chosen to do so, considering their mental and physical condition and position with relation to each other at the moment of inscription of each signature. The directory part is the place of the signature, that is the left margin. The signature can be affixed anywhere on the page. And finally, each and every page except the last must be signed by the testator or by the person requested by him to write his name and by the instrumental witnesses of the will on the left margin. Signatures in the left margin on each and every page. But this is not required in the last page when the will consists of 2 or more pages, or when the will consists of only 1 page, or when the will consists of 2 pages. The first consists of all the testamentary disposition and is signed at the bottom of the testator, and the witnesses in the second contains only the attestation clause duly signed at the bottom by the witnesses. Further, each and every page of the will must be numbered correlatively in letters placed on the upper part of each page. So the mandatory part again is the pagination by means of a conventional system. Directory part only is the pagination in letters on the upper part of the page. It must contain an attestation clause stating the following: the number of pages used upon which the will is written, The fact that the testator signed the will on every page or caused some other person to write his name under his express direction in the presence of the instrumental witnesses. All the instrumental witnesses witnessed and signed the will and all its pages in the presence of the testator and of one another. It must be acknowledged before a notary public by the testator and the witnesses. Attestation means an act witnessing execution of will by testator in order to see and take note mentally those things are done which the statute requires for the execution of the will, and that the signature of the testator exists as a fact. The attestation clause need not be written in a language or dialect known to the testator nor the witnesses, since it does not form part of the testamentary disposition. The attestation clause need only be signed by the witnesses and not only by the testator, as it is a declaration made by the witnesses. In Icasiano versus Icasiano, the inadvertent failure of one witness to affix his signature to one page of the original will due to simultaneous lifting of pages in the course of signing is not per se sufficient to justify denial of probate when the duplicate will show that he signed it. In Cruz versus Villasor, the notary public cannot be counted as one of the attesting instrument. Subscription, the manual act of instrumental witnesses in affixing their signature to the instrument. Attestation means acts of the senses. It's a mental act. Purpose is to render available proof during the probate that such will had been executed in accordance with the formalities prescribed by law, and it's found after the attestation clause at the end or last page of the will. Subscription, on the other hand, is the act of the hand. It's a mechanical act, and the purpose is for identification, and it is found at the left side margin of every page of the will. Holographic will. A holographic will is valid if it is in writing and in the language or dialect known to the testator, entirely written, dated, and signed by the hand of the testator himself. Dispositions of the testator written below his signature must be dated and signed by him in order to validate the testamentary disposition, except in case of dispositions appearing in a holographic will, which are signed without being dated, where the last disposition has a signature and a date. Such date validates the disposition preceding it, whatever be the time of prior dispositions. A holographic will is subject to no other form and may be made in or out of the Philippines and need not be witnessed. Probate of holographic will. There must be at least one witness, except if the will is contested, at least 3 of such witnesses shall be required. Merely directory. In the absence of such competent witness, and if the court deems it necessary, except testimony may be resorted to. Who knows the handwriting and signature of the testator must explicitly declare that the will and the signature are in the handwriting of the testator. Note, this article applies only to post-mortem probates and not to ante-mortem probates, since in such cases, the testator himself files the petition and will identify the document himself. In Gan versus Yap, 104 Phil 509, in the probate of a holographic will, the document itself must be produced. A lost holographic will cannot be probated. Exception, when copy of the will is produced. Insertion, cancellation, erasure, or alteration in a holographic will. What is the effect? If made after the execution of the will, but without the consent of the testator, such insertion is considered as not written because the validity of the will cannot be defeated by the malice or caprice of a third person. If the insertion after the execution of the will was with the consent of the testator, the will remains valid, but the insertion is void. If the insertion after the execution is validated by the testator by his signature thereon, then the insertion becomes part of the will, and the entire will becomes void. because of failure to comply with the requirement that it must be wholly written by the testator. If the insertion made by a third person is made contemporaneous to the execution of the will, then the will is void because it is not written entirely by the testator. What is formal validity? If the testator is a Filipino and the will is executed in the Philippines, then its formal validity is governed by the Civil Code of the Philippines. If the testator is a Filipino and the will is executed in a foreign country, then its formal validity is governed either by the law of the place where the will was made or by the Civil Code of the Philippines. If the testator is a foreigner and the will is executed in a foreign country, then its formal validity is governed either by the Civil Code of the Philippines or by the law of his own country. If the testator is a foreigner and the will is executed in a foreign country, then its formal validity is governed either by the law of the place where the will was made, by the law of his own country, by the law of the country where he resides, or by the Civil Code of the Philippines. Validity of joint wills. Two or more persons cannot make a will jointly or in the same instrument, either for their reciprocal benefit of a third person. No, joint wills executed by Filipinos in a foreign country shall not be valid in the Philippines, even though authorized by the laws of the country where they may have been executed. Amendments of wills, notarial, only through a council. Holographic, in 3 ways. Dispositions may be added below the signature, provided that said dispositions are also dated and signed, and everything is written by the hand of the testator himself. Certain dispositions or additional matter may be suppressed or inserted, provided that said cancellation is signed by the testator and written by the hand of the testator himself. And 3, through a codicil, which may either be notarial or holographic. Elements of a codicil. It is a supplementary or addition to a will, made after the execution of the will, and annexed to be taken as a part thereof, and 4th, by which any disposition in the original will may be explained, added, or altered. Requisites for incorporation by reference. 1. The documents or paper referred to in the will be in existence at the time of the execution of the will. The will must clearly describe and identify the same, stating among others things the number of pages thereof. It must be identified by clear and satisfactory proof as the document or paper referred to therein. It must be signed by the testator and the witnesses on each and every page, except in case of voluminous books of accounts or inventories. In Article 8.3.2, it says that a revocation made in a subsequent will shall take effect even if the new will should become inoperative by reason of the incapacity of the heirs, devices, or legatees designated therein, or by their renunciation. Exception is in the case of Molo versus Molo, 9T Fel 37, when the testator provides in the subsequent will that the revocation of the prior one is dependent on the capacity or acceptance of the heirs, devices, or legatees instituted in the subsequent will, which are the dependent relative revocation. In Article 834, under Article 834, the recognition of an illegitimate child does not lose its legal effect, even though the will wherein it was made should be revoked. While in Article 837, if after making a will, the testator makes a second will expressly revoking the first, the revocation of the second will does not revive the first will, which can be revived only by another will or codicil. Facts demonstrated Article 837. In 1985, X executed will number 1. In 1987, X executed will number 2, expressly revoking will number 1. And in 1990, X executed will number 3, revoking will number 1. Conclusion on the facts. The revocation of will 2 by will 3 does not revive the will number 1. This demonstrates the theory of instant revocation because the vocatory effect of the second will is immediate upon the first will. Note, this article only applies where the revocation of the first will by the second will is express. What is probate of a will? Probate of a will is a special proceeding required for the purpose of establishing the validity of the will. Probate of a will is mandatory. The probate court can only inquire into the extrinsic validity of testamentary provisions, which include the following: 1. That the testator was of sound and disposing mind. 2. That his consent was not vitiated. 3. That the will was signed by the required number of witnesses. And 4. That the will is genuine. The exception is the case of Nugid versus Nugid 17-449. The probate court may pass upon the intrinsic validity of the will when its probate might become an idle ceremony if on the will's face it appears to be intrinsically void. Kinds of probate: post-mortem after the testator's death or ante-mortem during his lifetime. Final decree of probate: once a decree of probate becomes final in accordance with the rules of procedure, it becomes res judicata. It is conclusive as to the due execution of the will, extrinsic validity only. Revocation means the voluntary act of the testator, with or without cause, may be partial or total, while disallowance means that this is given by judicial decree, always for a legal cause, and always total except when the ground of fraud or influence, for example, affects only certain portions of the will. Institutions of heir. It is an act by virtue of which a testator designates in his will 2. The person or persons who are to succeed him in his property and transmissible rights and obligations. Requisites for a valid institution of heir. Designation in will of persons to succeed. A. Directory means designation of name and surname. B. Mandatory. Identity of the heir must be established, otherwise void disposition unless his identity becomes certain. Note, if there is ambiguity in the designation must be resolved by discerning the testator's intent. If the ambiguity cannot be resolved, intestacy to that portion results. Will specifically assigns to such person an inchoate share in the estate. The person so named has capacity to succeed, and the will is formally valid. No vice of consent is present. No preterition results from the effect of such will. 3 principles in the institution of heirs. Equality. Heirs who are instituted without a designation of share inherit in equal parts. Individuality. Heirs collectively instituted are deemed individually named unless a contrary intent is proven. Simultaneity. When several heirs are instituted, they are instituted simultaneously and not successively. Preterition. There must be an omission of one, some of all the heirs in the will. The omission must be that of a compulsory heir. Compulsory heirs omitted must be of the direct line. The omitted compulsory heir must be living at the time of testator's death, or must be at least have been conceived before the testator's death. The omission must be completed and total in character. There is no omission if A. A device or legacy has been given to the heir. B. A donation inter vivos has been previously given to the heir. And C. Anything is left from the inheritance which the heir may get by way of intestacy. Distinguish preterition from disinheritance. In preterition, deprivation of a compulsory heir of his legitim is tacit. May be voluntary, but the law presumes that it is involuntary. Law presumes that there has been merely an oversight or mistake on the part of the testator. In preterition, omitted heir gets not only his legitim, but also his share in the free portion, not disposed of by way of legacies or devices. While for disinheritance, deprivation of the compulsory heir of his legitim is express. It is always voluntary. and it is done with a legal cause. If this inheritance is unlawful, compulsory heir is merely restored to his legitimate. Fideicommissory substitution exists if the testator institutes an heir with an obligation to deliver to another the property so inherited. The heir instituted to such condition is called the first heir or fiduciary heir, and the one receiving the property is the fideicommissory or second heir. Requisites for a fideicommissory substitution. 1. A fiduciary or first heir instituted, entrusted with the obligation to preserve and to transmit to a fideicommissory substitute or second heir the whole or part of the inheritance. 2. Such substitution must not go beyond 1 degree from the heir originally instituted. 3. The fiduciary or first heir and the second heir are living at the time of the death of the testator. 4th, the fideicommissory substitution must be expressly made. 5. The fideicommissory substitution is imposed on the free portion of the estate and never on the legitimate. Note, however, that pending the transmission of the property, the fiduciary is entitled to all the rights of a usufructuary, although the fideicommissory is entitled to all the rights of a naked owner. Classes of compulsory heirs. 1. Primary, those who have precedence over and exclude other compulsory heirs, legitimate children and descendants, legitimate with respect to their legitimate parents and descendants. Secondary, those who succeed only in the absence of the primary heirs, legitimate parents and descendants, legitimate with respect to their legitimate children and descendants. Concurring are those who succeed together with the primary or the secondary compulsory heirs, like widow or widower legitimate. The surviving spouse referred to is the spouse of the decedent. Note, a mere estrangement is not a ground for the disqualification of the surviving spouse as heir. Effect of degree of legal separation. On the offending spouse, disqualified. On the innocent spouse, no effect. Death of either spouse during the pendency of a petition for legal separation, dismissal of the case. Reserva tronco is the reservation by virtue of which an ascendant, who inherits from his descendants any property which the latter may have acquired by gratuitous title from another ascendant or a brother or a sister, is obliged to reserve the property from the benefit of relative within the third degree and who belong from the same line from which the property came from. It constitutes as an exception to both the system of legitimate and the order of intestate succession. And the purpose of reserva tronco is to receive certain properties in favor of certain persons, to prevent person outside a family from acquiring by some chance or accident property which otherwise would have remained with the said family. 3. To maintain a separation between paternal and maternal lines. Requisites of reserva tronco. The property should have been acquired by operation of law by an ascendant or the reservista from his descendant or propositus upon the death of the latter. 2. The property should have been previously acquired by gratuitous title by the propositus from another ascendant or from a brother or sister or the originator. Note, gratuitous encompasses transmissions by donation and succession. And 3. The propositus should have died without any legitimate issue in the direct descending line who could inherit from him. Note, Nieva versus Alcala 41 Phil 495. All relationships must be legitimate. Note, however, that in case of Gonzalez versus CFI 104 Phil 479, the reservista had not power to appoint by will which reservations were to get the reserved property. Requirements for valid disinheritance. 1. Effected only through a valid will. 2. For a cause expressly stated by law. 3. Cause must be expressly stated in the will itself. 4. Cause must be certain and true. 5th, unconditional. 6. Total. And 7. The heir disinherited must be designated in such a manner that there can be no doubts as to his identity. Imperfect disinheritance. Disinheritance which does not have one or more of the essential requisites for its validity is called imperfect disinheritance. Effects of imperfect disinheritance. If the testator had made disposition of the entire estate, annulment of the testamentary disposition only insofar as they prejudice the legitime of the person disinherited does not affect the dispositions of the testator with respect to the free portion. If the testator did not dispose of the free portion, compulsory heir given all that he is entitled to receive as if the disinheritance has not been made, without prejudice to lawful dispositions made by the testator in favor of others. Devices, legacies, and other testamentary dispositions shall be valid to such extent as will not impair the legitime. Revocation of disinheritance. 1. Reconciliation. 2. Subsequent institution of the disinherited heir. 3. Nullity of the will which contains the disinheritance. Note, however, that where the ground for disinheritance is also a ground for unworthiness to succeed, what is the effect of the subsequent reconciliation upon the heir's capacity to succeed? 1. If disinheritance has been made, rule on reconciliation applies. The disinheritance becomes ineffective. If disinheritance has not been made, the rule on reconciliation does not apply. The heir continues to be incapacitated to succeed unless the testator pardoned him under Article 1033. Basic principles in intestate succession. Intestate heirs always related by blood, except spouse not related by blood, stranger in the family. B. Adoptive relation, adopter or adopted, fiction by law created by adoption, purely personal. And in case no heir can inherit, it goes to the state. Number 2, the near excludes the farther, rule of proximity. The relative nearest in degree exclude the farther ones. 4. Direct line is always preferred over collateral. 4th, ascending line is always preferred over collateral. Descending line is always preferred over ascending and collateral lines. 6. Rule of equal division. The relatives who are in the same degree shall inherit in equal shares, same class, exception. And by the way, if you're not yet subscribed to this channel, please go ahead and hit that subscribe button and hit the notification bell. It's free. Thank you. Exception is in the descending line. Difference in class in the cases of legitimate filiation, that is in case of paternal or maternal lines, or collateral, like half or full blood. In the ascending line, the shares are divided equally between maternal and paternal lines, which could result to unequal shares when there is only one grandparent in the maternal line, while both grandparents survived in the paternal side. Note, in all cases where there has been an institution of heirs, follow the ISRA order of Justice Paras. If the institution fails, substitution occurs. If there is no substitute, right of representation applies in the direct descending line to the legitime of the vacancy is caused by predecease, incapacity, or disinheritance. The right of accretion applies to the free portion when the requisites in Article 1016 are present. If there is no substitute, and the right of representation or accretion does not apply, the rule of intestate succession shall take over. Instances when representation occurs: 1. Predecease. 2. Incapacity or unworthiness. 3. Disinheritance. Note, in case of repudiation, accretion takes place. In Sison v. CA 205 SCRA 324, although a renouncer cannot be represented, he can represent the person whose inheritance he has renounced. In what kinds of succession representation operates? 1. Legitimes. The children and descendants of the person disinherited shall take his or her place and shall preserve the rights of compulsory heir with respect to the legitime, and only when the heir to be represented 1. Predeceased becomes incapacitated or was disinherited by the testator and is a compulsory heir, and no right of representation if the heir to be represented is a voluntary heir. Number 2. Interstate succession. When the person died without a last will, the share in the inheritance is called intestate share. And under the Philippine law on intestate succession, only compulsory heirs of the deceased are entitled to inherit from his or her estate. Other relatives may inherit only upon default or absence of the compulsory heirs.